Hi, Nan Jensen here. This is video number 7 in the Preparing for Adulthood series, and it is about enduring powers of attorney. First, my disclaimer. These videos contain information, not advice. If you need legal advice, you need to speak to a lawyer, you need to give them all your information, and you need to get a letter of engagement from them. So don't rely on anything you hear here. This is only information. It is not specific advice for you. Okay, so today's topic is enduring powers of attorney. Enduring powers of attorney are under the Protection of Personal and Property Rights Act, just like welfare guardian and property manager. And similar to those, enduring powers of attorney are divided up between personal care and welfare and property. Now, before I talk about enduring powers of attorney or even powers of attorney, I just want to talk about the word attorney. I've run into a number of people who think that attorney means lawyer. They've been watching American TV because it does mean that in America, but that's not what it means in New Zealand. An attorney is a person that you appoint to act on your behalf. In other words, you give them authority to make decisions on your behalf. Now, normally it will be limited to certain types of decisions. So that's what an attorney is. And you can give power of attorney and you can give enduring power of attorney. And there's a difference between the two. So let's just talk briefly about power of attorney. Power of attorney is something that you give while you have capacity. So you must have capacity. You must understand what is in the document and what the power is that you are giving away. And normally it's something quite specific, and it may be for quite a limited purpose or period of time where you authorize someone else to act on your behalf. It might be to sign a contract or something. Now, that kind of power of attorney is only valid either as long as the document says it is, but it certainly stops being valid if you lose capacity or you die. So that's an ordinary power of attorney. So now we have enduring powers of attorney under the PPPR Act, and enduring powers of attorney are different because they endure past the point where the donor loses capacity. You still need to have capacity in order to give enduring power of attorney. So if you are someone who was born without capacity and has never had capacity, or at least the capacity to understand such a document, then you will not be able to give power of attorney. And if you need someone to make decisions on your behalf, then someone will have to apply to be your welfare guardian or your property manager or both. So enduring powers of attorney are for people who have capacity to understand what the document is about. So just to give an example, let's say that my husband has a lot of property and he travels a lot. So because of that, he gives me an enduring power of attorney in respect of personal care and welfare, and that allows me to manage the property while he is overseas. So I manage it on his behalf. Now let's say he's also given me an enduring power of attorney in respect of personal care and welfare. Well, in that case, he's obviously going to make his own decisions about what he's going to wear and what he's going to eat, give his own medical consent, and decide where he's going to live. All those personal care and welfare decisions, he'll do that as long as he has capacity. Now let's say that he goes overseas and he has an accident and he loses capacity. Well, I'm going to be able to continue to manage his property on his behalf because he's given me that enduring power of attorney, which endures past the point that he loses capacity. So I've got that one in respect of property, and therefore I can continue to manage the property. Similarly, with the personal care and welfare one, because he's given me that, if he comes back with an injury and has lost capacity, I can give consent for him to go, for example, into a rehab facility or to have any medical treatment that he needs. So that's how those documents are useful. Now let's say that he hadn't given me the power of attorney and he came back and had an injury. What then? He's lost capacity. Well, I would have to go to the court and apply to be his welfare guardian and possibly his property manager as well. So you'll remember that we talked about those in earlier videos. This is one of the most important videos, Enduring Powers of Attorney, because they apply to everybody. Anyone can have an accident at any time. I have people who tell me, oh no, we're not old enough, we don't need them yet. Well, in my view, everybody needs them. I know it sounds like I'm trying to advertise for lawyer services. Believe me, we don't make that much money on them, but they're really, really important that people have these done, because anyone can have an accident at any time and lose capacity, and it's a whole lot easier for your family member to invoke an enduring power of attorney that you already prepared than it is for them to have to start going to court to apply to be your welfare guardian and property manager at the point where that happens. I had my children do powers of attorney, enduring powers of attorney, as soon as they turned 18. So that's the age when you can do them. I think it's really important. Not giving you advice, just a suggestion. There are a lot of different things that the donor of the power can decide about. So I'm not going to go into a lot of detail, but one of those things is whether you want gifts to be given on your behalf, and other things are whether the donor can, the attorney can modify your will or make a new will for you. Now, as long as you have capacity, you can always revoke the power of attorney. So you may have chosen to give it to somebody and then you've changed your mind, or you might have chosen a substitute attorney and that person dies or moves away, and so you want to replace them with someone else. So there's a number of different options, and you can put a number of substitutes as well. Similarly to with property manager, you can choose 2 people to be attorneys for property. You can only have one personal care and welfare person at a time, but you can put several in the document. Now, for the people acting as attorneys, it's really, really important to understand that your responsibilities are similar to those of a welfare guardian or property manager. And that is that even if the person has lost capacity, you still need to consult them. You need to encourage them to use their capacity as much as possible. You can't just ignore them and do whatever you want with their property and their personal care just because you're now the attorney. So it's a similar situation. And in either case, in my view, the person can act badly or they can act well. So I don't believe that one of these gives the donor or the subject person more autonomy than others. I think they're very similar. It just really depends on how the attorney or the appointed person carries out their role. So it's really important for whoever is appointed, whether they're appointed by the court or appointed by the donor of the power, that they understand their role and they understand that they still need to be thinking about the other person and empowering them as much as possible. So I think I covered everything I wanted to talk about there. Oh, yes, that's right. There are some resources that I will put links to if I can find them. One is that there's documents about enduring powers of attorney in a variety of different languages, so I'll put that up so people can find it in their own language if they prefer that to one in English. And the other thing is that there is a document, I found it on the People First website. It's an easy read document about enduring powers of attorney, and so if you are a person with a cognitive difference or a learning issue, then it may be really helpful to look through that before you see a lawyer about witnessing powers of attorney, so that you can make some decisions and have a good idea of what it's about. Now, lawyers witness these documents. You must use a lawyer to get it witnessed, and it's really important that you understand what's in the document. Otherwise, the lawyer won't witness it for you, because in the end, we're the ones who get in trouble if we allowed someone without capacity to sign a power of attorney. Okay, so that's all for this topic. The next video will be about wills. Thanks for listening.